of 2022.
Before I take the topic to the government of the appellate court, it is necessary to see the exhibit X again. Because my friend was going, I have not intervened much, my lord. Now my lord has given opportunity to me, my lord, to take your lordship. If my lord will see which portion was marked as exhibit 3 is very important. The exhibit 3 is not marked to the photocopy. The photocopy is marked as exhibit X for identification. But the portion which is marked separately after giving a and a ring, where there it is written, मतलब दोनों पक्षों की सहमति से इसे the photocopy इसे मूल इकरारनामा समझा तथा लेखाकारी को सौंपा. This photocopy was treated as the original, as
if it's a carbon copy.
As the original and signed by both the parties. And that's why, my lord, my endorsement and the signature of the plaintiff and the signature of the defendant was marked separately as exhibit 3 and as exhibit 3 by A.
Without any objection.
Without, because this is their signature. They have not disputed their own signature in the agreement. And this was argued before the learned appellate court. My lord will find endorsement discussion at page 51. Because this is the most vital document which is totally ignored by the trial court. That they have failed to give the agreement. This is the original agreement. And it is certified by the defendant himself that this will be treated as an agreement, and the copy was given to the lekhakari. My lord was asking, who is lekhakari? The plaintiff is lekhakari. My lord, page 57 towards bottom, my lord, 4-5 lines. Moreover, my lord, get it. Moreover, the signature and the endorsement of the plaintiff and the signature of the defendant over the said rent agreement has been exhibited as exhibit 3 and 3 by A, respectively, over the rent agreement, but the learned trial court has not considered and weighted the evidence and material available on record. The learned trial court has considered that the suit premises is situated in the ground floor of the temple of so and so, so and so, because otherwise those are not material. That is admitted question that
the location and position of the shop is not in this.
Nothing to do. I will not waste my lot of time. This was very important factor, my lord.
The defendant respondent.
Moreover, Burha Mahadev, in fact, was also stated that defendant witness was that there is a single staircase in which person entered into temple, because they said, my lord, that in front of the temple they have got this up. And
the defendant respondent has only denied the signature. Yes, read it please.
I am reading. Defendant witnessed there a single staircase which is person may enter into temple of Burha Mahadev as well as the temple of Devi Vaishno Mata. But the defendant tried to mislead that Vaishno Mata temple and Burha Mahadev temple are not in the same room. The defendant respondents are only denied the signature over the rent receipt, but not tried to get it examined by the handwriting expert, whether these bear the signature of defendant or not. Moreover, there is also no explanation on sending the rent through money order, exhibit 2 series, and as said, the trial court has failed to appreciate the evidence and the material available on record in true state of the affair, and the learned trial court ought to have been held that there is a relationship of the landlord and tenant. Now, my lord, I was taking your lordship to the point number
There
B.
is a discussion of
Why not?
the signature he did not deny. This is what.
It is not denied.
Yes.
They have never said, they have simply said that rent receipt is false. And in front of them, their signature is marked as Exhibit 3 by A. My signature is marked as Exhibit 3 with the endorsement that this photocopy will be treated as original with the consent of the parties. Even then they have denied and said it is a false document. Every tenant says a false document because they have to continue with the tenancy. So that, but the trial court should have understand that the denial is only for the sake of denial. There is no proof otherwise. Then my lord, page 58. My lord wanted to know where the discussion of the appellate court. Page 58, second paragraph. For such consideration, from top, for such consideration, it is obvious that the admitted fact, that it is admitted fact between the parties that Burha Mahadev Mandir, which is very old, the claim of the plaintiff that has inducted the defendant as a tenant through agreement of tenancy dated 16/6/1999. It is further claimed by the plaintiff that defendant has paid the rent up to the month of June 2005. Thereafter, he neglected and defaulted in payment of rent since that date. With the regard, plaintiff relied on Exhibit 1 series as well as Exhibit 2 series, that is rent receipt and many others respectively. So these things are admitted because they have simply said denial for. Then from bottom, more of
Then is 22
Pura pad दें. Well, on the other hand, the defendant has not specifically denied about the induction on the suit premises by the plaintiff, rather stated in paragraph 21 of his written statement that the defendant, with respect of the authority, has constructed one of the stock, put, shuttered and opened the stock, dealing in puja samagri in name of so-and-so, situated in opposite of Durga Mahadev temple, intervened by the road. Moreover, Durga Mahadev temple under the Hindu Religious Trust Board, which is but the defendant in support of this claim could not produce any document that authority has allowed the defendant to construct the suit premises. Moreover, there is no document produced by the defendant to establish that the Durga Mahadev temple is under control of the management of Hindu Religious Trust Board. Jharkhand, rather Exhibit 1 and 2 series rent receipt signed by the defendant also, which is clear that is stated that the rent receipt have been issued with regard to the shop situated in below the temple of Durga Mahadev and not examined by. Moreover, from bare perusal of the signature of defendant over the rent receipt, Exhibit 1 series हुजूर के पास असल में हम चेक किए हुजूर का रिकॉर्ड, तो एग्जिबिट जो आया है उसका सब जेरोक्स कॉपी है, ओरिजिनल हुजूर के पास रहता तो उसमें सब ओरिजिनल सिग्नेचर है जो एग्जिबिट 3 और 3/A मार्क होगा। हम इसलिए कंसर्न लॉयर से पूछे अभी, तो बोले वो ओरिजिनल सिग्नेचर था उसको ही मार्क हुआ, बाकी जो कंटेंशन है वो एग्जिबिट X है बिकॉज दैट इज फोटोकॉपी।
फोटोकॉपी पर ओरिजिनल
सिग्नेचर
जिसको सोचे थे कि कोर्ट ऐसे तो नहीं मार्क करता
हमको ये पजल हमको भी समझ नहीं आ रहा था तो इसीलिए वाइट।
आप बताइए आपको क्या पता।
Malets, I will just refer to Exhibit C, that is the order of the Honorable Patna High Court in CWJC number 3249/94।
उसमें ये पार्टी है?
हाँ, उसमें ये पार्टी यही कर रही है क्योंकि ये कुछ जमीन जो है वहाँ का ये इंक्रोच कर लिए थे, स्टेटिंग दैट कि ये मेरी जमीन है और उस पर कंस्ट्रक्शन कर ली। तो स्टेट ने कहा LRDC और द हजारीबाग एग्जिबिट नंबर C है, ये है एग्जिबिट नंबर C,
हाँ,
सर्टिफाइड कॉपी ऑफ ऑर्डर डेटेड 5/2/1996।
ठीक,
मैं
5/2/3249।
हाँ, 3249 सर्टिफाइड कॉपी है। मैं रीड दैट वन। She, may I read, my lord? Heard Mr. Kumar for the petitioner. Petitioner is Pramod Kumar Misra, the plaintiff, and the learned government advocate. This writ application is directed against the order dated 19/10/94, passed by appellate authority under the Bihar Land Encroachment Act 1956, by a reason of which he has dismissed the appeal referred by petitioner and confirmed the order dated 5/8/93, passed in land encroachment case number 46/90. It appears that the notice was issued to the petitioner under the section 3 of the Act, calling upon him to show cause as to why the encroachment of the portion of the land should not be removed. The petitioner, it appears, filed his show cause annexure 2 containing inter alia that Burwa Mahadev temple is situated behind since over 100 years, and the petitioner is the pujari of temple. In para 6 of the show cause, he has asserted that he was told by his father that the land of the temple was settled in the name of temple long back. Another show cause was also filed in Annexure 3, in which it was stated that proceeding is bad because only the delineation has been given and not to the boundary of the land in question. By order dated 6/93, the respondent number 2, after perusing the documents and hearing the parties, had come to finding that this is the main point I am going to focus, my lords. After perusing the documents and hearing the parties, has come to finding that the land in question is Kesari Hind land, in which such view of the matter is it is a public land defined under the Act, and that's why we are paying rent to the government. The said authority has further come to finding that the construction has been made by the petitioner and not by any association or society. Mr. Kumar has given preference to the decision of the Honorable Report in 1982-1084 BLJR 1051AR 1955, in as much as the temple in question is situated over the land for more than 100 years, and as such it cannot be said that it is a public land. In counter affidavit, the LRDC Hazaribagh has categorically stated the petitioner has encroached upon the land adjacent to the temple, and the proceeding has been initiated on the portion of the adjacent land to the temple and not in respect of the temple itself. Referring to the map, Annexure 1, categorically a government has been made that a portion marked red in the marked red is the temple, and the same is not a subject matter of the proceeding. On the other hand, the portion shown in the green color is the said map will show the petitioner has encroached this land adjacent to temple and has constructed 2 rooms adjacent to the temple for his personal use. In para 10, it is categorically stated that the land in question has been recorded as Kesari Hind land in the records of the rights, and the temple is in existence over the land and since more than 100 years. But present proceeding is not respect to the land on which the temple is situated. This proceeding is on the portion of the land encroached by the petitioner, where rooms have been constructed by him. The aforesaid government made in the court affidavit has not been controverted by the petitioner. In as such view of the matter, in my opinion, the petitioner has not acquired any right, title, interest over the land in question, in which this is the order matters. We have referred this judgment on as an exhibit C.
It is apparent from the judgment, my lord, that the temple was marked separately in the red, but the unauthorized occupation was marked separately. That portion was under dispute because certain 2 rooms were constructed in the unauthorized premises area, which has been questioned. And my lord, that was already dismissed. And my lord, the Honorable High Court in contempt, they have confirmed that temple is intact. The side portion they have demolished. So if it is already demolished, then his shop is not available there. If he is fighting for the shop, that shop is in the temple, then temple was never in the question.
How the courts have dealt with Exhibit A series? How the courts have dealt with Exhibit A series?
That one not the learned appellate court has had.
Where is that? Where is the finding with
Well,
respect to A series?
It has said, my lord, by the learned appellate court, that he has read, my lord, I was just read over, my lord, in para 22, page 58. page para 22. After the one fact they have tried to mislead that this temple is in front of Budwa Mahadev area. In between there is a road, and I am out other side of the road, not in the temple. But their own witness confirms that we are in the temple, and there is one stair, and above the stair there is a temple.
So
There
where is
after-
the discussion of exhibit?
Then
A?
they are
My
just
answer
there
is
after.
on page number 30, trial court has discussed it.
The
Appellate
are-
अच्छा,
उसी का उसमें फिर सेकंड लाइन में आता है आफ्टर 5 लाइन्स इन पैराग्राफ 22 moreover Budwa Mahadev temple is under Hindu religious trust board Ranchi, but the defendant in support of his claim not produce any document that any authority has allowed the defendant, because they claim that we have constructed the shop under permission of. There is no document produced by the defendant to establish that the Budwa Mahadev temple is under control of the management of Hindu Religious Trust Board, Jharkhand. Rather, Exhibit 1-2 series rent receipt signed by them. My lord, if they will go before the treasury and give some money, they will accept money. But that does not dissolve them from my tenancy. Because no tenancy and neither there is any tenancy, neither there is a trust. Till that the mandir is in my occupation, 2002 judgment I have
They
got.
claimed that it's a trust property.
No, my lord. It is, my lord, that
They
government.
claimed that it was trust
They
property.
claim. Without any.
There was no evidence that there was any trust.
My lord. To the contrary, my lord, page 46, my lord, will just come. Of the appellate court judgment, running page 46. In the bottom, my lord, in his cross examination, he has stated that he has seen khatiyan of the suit premises before filing of this case, and which is registered in the name of the plaintiff's grandfather, namely so and so, and in the last cadastral survey of the khata number suit premises 305, so and so, and the total area is 8 acres, and so late Raghunandan Mishra acquired the suit land, were given by Raja of Ramgarh. Presently, the rent receipts are being issued by the state. The Budwa Mahadev Mandir is situated over 6 decimal of the land, and a pound situated in the north side. So, my property mandir, even that judgment, my lord, of the Patna High Court says that this mandir is in red. The rest of unauthorized occupation in the side of the mandir was colored separately. So, my mandir was never in question of the disputed. Undoubtedly, the unauthorized portion was Kesre-Hind Jamin, and that Jamin was of the state. That land was state. Even in contempt, they have filed so-called that mandir is intact, the unauthorized occupation is demolished. But you are not occupying in the unauthorized occupation.
My lords, after that words, उसके आगे थोड़ा पढ़े my lord लिखा हुआ है उसी पेज नंबर 47 what my learned friend has read. He admitted this fact that for the encroachment of the land around the Budwa Mahadev Mandir, an encroachment case number 4699 has been instituted against
That
him.
is around
It is an admitted case.
That is around the property.
Yes.
That is around the
And it
property.
is their case that it was in connection with that property which was
Yes.
around the temple,
Around
the
it.
encroachment case was started.
Yes.
And you have tried to mislead the court that no, this land they have no right. And the learned subject accepted that. Although he has got no right to challenge my title.
That's all about that judgment.
Man,
अब इनको बोलना
man.
जो आपको बोलना है response में.
And let's the question which has been raised here. The issue is regarding the relationship of landlord and tenant. We have just focused on the question that the land on which we are having our shops, we are running our shops. So that land will belong to the landlord. Who is the landlord? The plaintiff is claiming that I am the landlord of that place, concerned place where the shop is located. He is stating that the land is on the name of my grandfather, which is in the cadastral survey Khatiyan. It is on the name of my grandfather. of 8 decimal lands, which is now running, still running. But whether after filing the suit for the eviction of the land, whether any papers regarding the possession of the land or having the right over the land, whether it has been filed before the trial court, concerning that yes, this land belongs to me. If for example, if we stand in a place, we say that yes, this is my land, we are not having any papers, we are standing there for long.
Khatyan was produced?
Months.
Khatyan was produced?
No, it was not produced. It has not been produced
Eviction
before
suit, it
the
is
court.
not required. That's why the learned appellate court said it is what is required, that the relationship is to be established. And he has quoted the entire act itself, my lord. Entire act is mentioned.
It has not been produced. Later on, the case has been filed, and they are stating that yes, this is my land premises, the shop is running, and I am entitled for the rent because they are the tenants. This is the question, and the question which has been framed, that landlord and tenant relationship. But how the landlord and rent tenant relationship will be proved? It will be proved by the documents. They have produced the documents like Exhibit 1 to the rent receipt. But the question is that whether we have not objected on that much portion of the rent receipt on which he has given in the case, filed in the case, which are marked as exhibits. Now, later on, our case is that we are focusing on that no, there is no landlord and tenant relationship is established there, because if he is the landlord, he has given the land to us for the tenancy, then where are the papers? Papers required, it is not available on the record. Khatyan is not available on the record, which will show that yes, they are the owners. Second most essential question rises that whether we are running the shop, whether we are paying rent to anyone. Yes, we are paying rent to the government. We have annexed the rent receipts, and we claim that this is not the land of the plaintiff. This is the land of the Kesari Hind, which has been acquired by the Raja Ramgarh and which has been later on converted into the Kesari Hind, and this is the land of the government. The government has acquired that land. It is in the possession of the government. We are paying rent to the Anchal Adhikari Hazaribagh, the rent taking officer. These are available on the record. We have paid that. And hence, my lords, my final argument is that the landlord-tenant, until the landlord-tenant relationship is not established, the plaintiff is not entitled for the leave for taking the rent from us and evicting us from the suit premises, my lords.
Heard the learned counsels on behalf of the parties. This
One thing, if my lord permits, there is no argument regarding Exhibit 3 and 3/A. They have simply again ignored the lordship. And my lord, the Exhibit A series, that is the rent receipt they produced, is of 2010. That is all of 2009-10. And the admitted case of the defendant that they are running this shop since 1999.
It is from
From 2005 onwards,
2003 onwards.
6 onwards.
2003, it is the
Right.
exhibit number 1 by C.
Page 23 is there. I talked through document. Exhibit 3, and it is the case of the plaintiff कि 2005 के बाद आप हमको रेंट नहीं लेना. Exhibit मार्क किया हुआ तो पेज 23 पैराग्राफ 8. ये जितना रेंट रिसीट अंचल अधिकारी का लगाए हैं, ये मिस्चीवियस बना के शुरू किए 2006 से. और इनका
2003 यहाँ लिखा हुआ है तो
सब
exhibit number 1 by C, rent receipt on plain paper dated 5/12/2003.
नहीं पैराग्राफ नंबर 8
8 पढ़िए ना, पैराग्राफ 8 पढ़िए.
एक का डेट भी दिखा है।
सबका डेट दिया हुआ है. Now my lord, इनका अपना गवाही है, इनके गवाहों ने कहा है, अपने भी कहे कि हम 99 से हैं वहाँ। हमारा पास जो एग्जिबिट रिलेशनशिप इस्टेब्लिश करता है वो एग्रीमेंट है 99 का, और दोनों 99 से है। इनका केस 99 से है कि हम वहाँ 99 से रह रहे हैं। इनका जो विटनेस है वो कहा कि हम पर भी यही केस हुआ, हम इनके बगल के दुकानदार हैं, हम पर भी मिक्सर सूट चल रहा है, हम ये 99 से वहाँ पर है। और इनका यहाँ पर जो आ रहा है एविडेंस वो 2006 से है, और प्लेंटिव का केस है कि 2005 के बाद आप रेंट देना बंद कर दिया, एंड ही इज टोटली साइलेंट अबाउट दैट पार्ट ऑफ द एरिया। दैट्स ऑल।
Heard the learned counsel's appeal on behalf of the parties. This appeal has been filed against judgment and decree dated 23/5/2022. Decree signed on 6/6/22, passed in civil appeal within bracket title appeal bracket close number 50 of 2019 by learned District Judge Roman 4 Hazaribagh, who has set aside the judgment of the trial court judgment and decree of the learned trial court.
Yes, it might.
Yes. The learned trial court by judgment dated 10/6/2019 and decree signed on 22/6/2019 dismissed the eviction suit number 15 of 2011, and the judgment was passed by additional civil judge within bracket junior division bracket close Roman 3 Hazaribagh. This appeal was admitted for final hearing by order dated 16/9/2023 on the following substantial questions of law. The argument has been advanced on the first substantial question of law, and no endeavour has been made by the learned counsel for the parties to raise any other substantial question of law, although white paragraph Roman 2 of the order dated 16/9/2023, the parties were set at liberty to raise other and further substantial question of law at the time of hearing, if warranted in this case. The learned counsel for the appellant has submitted that the plaintiff had miserably failed to prove the landlord-tenant relationship. He has submitted that a photocopy of the tenancy agreement was produced, which was marked X for identification. The learned counsel has also submitted that the defendant had produced rent receipts rent receipt deposited before the rent receipts issued from the office of Anchal Adhikari Hazaribagh as contained in Annexure A series, and claimed that the property was Kaisare-Hind and the defendant was tenant under the state. The learned counsel has also submitted that the plaintiff claimed to be the owner of the property, but no khatiyan was produced to establish the ownership, Rather, no documents were produced to establish the ownership of the property. The Learned Counsel has further submitted that an encroachment case, a case was instituted under Bihar Public Land Encroachment Act against the plaintiff, which was ultimately subject matter of consideration in CWJC number 3249 of 1994 within the Guitar, in which the plaintiff was the petitioner. He has submitted that in the said case, the plaintiff of the present case had claimed that he was the pujari of the temple for and the temple, namely Budva Mahadev temple, was more than 100 years old. He has submitted that the property was held to be public land, and the order passed by the concerned authorities have been ultimately upheld in the writ application. The Learned Counsel submits that the petitioner had also the appellant tenant had also substantiated the relationship of landlord and tenant with the state, but the state was not a party before the learned court. He submits that these aspects of the matter have not been properly considered by the learned appellate court while upsetting the judgment and decree passed by the learned trial. छूट गया आपका? हो गया सर? The Learned Counsel, appearing on behalf of the respondent, has opposed the prayer and has submitted that although the photocopy of the rent agreement was exhibited and was produced and marked X for identification, but the signatures of the respective parties, including the plaintiff and the defendant,
Signature and endorsement.
says a signature along with the endorsement made therein was encircled and exhibited of the respective parties, and such exhibits were marked without any objection from the side of the defendant. He has also submitted that that in a matter relating to dispute between landlord and tenant, there is no need to establish the title over the property. The Learned Counsel further submits that the specific case of the plaintiff was that the defendant were defaulter right from the year 2005, and he submits that the defendant claimed that they were over the property as tenant of the state since the year 1999, but the rent receipts have been produced only from the year 2006 onwards as Exhibit A series. He has submitted that the defendant have stopped making payment of rent to the plaintiff and started making some payment to the Anchal Adhikari Hazaribagh, and state was not a party in the present proceedings. The learned counsel submits that the plaintiff had produced the money order receipts as Exhibit 2 series and also rent receipts, though on plain paper was due but duly signed by the defendant as Exhibit 1 series. He submits that the signature of the defendant on the rent receipts marked as Exhibit 1 series was not disputed, and these aspects of the matter have been taken into consideration by the learned appellate court to upset the judgment passed by the learned trial court. With respect to the proceedings which had taken place under the provisions of Bihar Public Land Enforcement Act, the learned counsel submits that the judgment passed by this court in CWJC number 3249 of 1994 with the bracket R itself revealed that the said judgment was in connection with the with certain property which was outside the premises of the temple, and there is nothing on record to show that the said litigation was in connection with the property which was in occupation of the defendant. The learned counsel has also submitted that the pleadings of the respective parties have also been taken into consideration by the learned appellate court, and thereafter the finding has been recorded. He submits that the question of law which has been framed by this court is fit to be answered against the appellant and in favor of the respondent. यही है आपका? After hearing the learned counsel's appearing on behalf of the parties and considering this court finds that the plaintiff had brought the suit for eviction of the defendant from the suit premises, which consisted of one room shop described in Schedule A of the plaint, and prayed for a degree of khas possession of the suit premises. It was the specific case of the plaintiff that the suit premises were let out to, that the plaintiff was the owner/landlord of the property, and it was let out to the defendant on a monthly rent of ₹600 on 16/6/99 by under a written deed of Kiraya Nama/agreement dated 16/6/99, which was subsequently, and the rent was subsequently enhanced to ₹660 per month. The plaintiff always used to demand and collect the monthly rent from the defendant, and for each payment used to grant a handwritten receipt to the defendant, and the defendant, in acknowledgement of the acceptance of rent receipt, put a signature on the handwritten receipt duly maintained by the plaintiff. It was a further case that the payment became irregular in the month of June 2005, and the defendant became defaulter from 7/10/2005 and had not paid rent since the month of July 2005. The total arrears of rent from June 2005 to March 2011 was rupees 44,850 at the rate of rupees 660 per month. a plea of personal necessity was also raised, and it was asserted by the plaintiff that the tenanted premises shop was required for construction of new foundation of iron wall of the temple. The plaintiff requested the defendant to evict the suit premises and for payment of rent, and ultimately the suit was filed. The defendant appeared and filed written statement, denied the relationship of landlord and tenant, and asserted that the plaintiff has to establish his right, title, and possession in a regular suit by paying ad valorem court fees, and the suit was not maintainable. It was asserted that the suit belongs to religious trust, and that the managing committee of the religious trust was a necessary party. It was denied that the plaintiff is the owner of the landlord of the shop. It was also denied that the shop room was given as monthly rental under a kirayanama. It was also denied that the plaintiff used to demand and collect monthly rent from the defendant, and for each month the plaintiff used to grant a handwritten receipt. And it was asserted that if any such receipt is produced, it must be false and fabricated and fraudulent. The plea of the mandir becoming in dilapidated condition was also denied, and it was asserted that the plaintiff is also occupying two shops under the same temple in unauthorized way. It was further stated that the land is Kaisari Hind, land of Khasmail government estate recorded as Tank and Pond, and ultimately the defendant prayed to it was also asserted that the defendant continued to deposit the rent in the office of Anchal Adhikari Hazaribagh, and a committee was constituted in supersession of Budva Maharaj Religious Trust / Budva Maharaj Mahadev Dharmik Nyas as per instructions of the Deputy Commissioner Hazaribagh, and consequently the rent was being paid by the defendants to the Antaladhikari, who was nominated as the president of the committee. The defendant ultimately prayed for dismissal of the suit. A reference was also made it was also alleged that the plaintiff was trying to make unauthorized construction over the Castle in land in which encroachment case number 46 of 1990 was instituted, and he was directed to remove the encroachment. The removal of encroachment was ultimately confirmed in writ petition being CWJC number 3249 of 1994. The defendant, in support of his case, produced number of rent receipts issued by circle officer from 5/5/2006 onwards. He also produced, which were marked as Exhibit A series. The defendant also produced certified copy of order dated 19/10/94 passed by the learned Additional Collector Hazaribagh in appeal preferred in encroachment case, which was in appeal preferred from encroachment case number 46 of 1990, and also the certified copy of the order dated 5/2/1996 passed by the High Court in CWJC number 3249/1994 within bracket R. In both the parties had examined one witness. The plaintiff had examined one witness, that is himself, and the defendant adduced two witnesses in favor of the case. The learned trial court considered the materials and took up the issue one by one from paragraph 15 onwards. The learned trial court first decided issue number 5. And observed that it was for the plaintiff to prove the relationship of landlord and tenant, and Xerox copy of the agreement dated 10/6/1999, which was marked X for identification, could not be taken as a substantive evidence of tenancy. And in absence of, the learned trial court was of the view that plaintiff, having failed to produce the original rent agreement, therefore in absence of a valid agreement of tenancy, he could not be said to be landlord of the suit premises. The learned trial court also referred to the rent receipts, Exhibit 1 to Exhibit 1/H, to establish the relationship of landlord and tenant, but the defendant claimed the agrees to be forged. The learned trial court was of the view that these rent receipts, having been prepared in such a manner that they seem to fulfill the absence of rent agreement, and this created a serious doubt about their genuineness. The learned trial court also considered the 5 rent receipts produced by the plaintiff through money order. But the trial court rejected the same by observing that the documents contained in an SU2 series was not having the seal of the postal department, and it created a doubt regarding its genuineness. The learned trial court considered the rent receipts exhibit A to A by 18 issued by the Anchal Circle Officer Sadar Zaribar in favor of the defendant, and also referred to the enforcement case number 46 of 1990 and observed that the plaintiff was held to be a trespasser and ultimately the appeal was also dismissed and the order attained finality in CWJC number 3249 of 1994. It was the learned trial court was of the view that the plaintiff failed to prove the valid document of tenancy, and the defendant created serious doubt on his claim of land, on his claim of landlordship over the tenanted shop premises, and ultimately held that the defendant cannot be said to be a tenant of the plaintiff, and decided the issue against the plaintiff. With respect to the point of default, as by issue number 6, the learned trial court was of the view that since the plaintiff failed to establish a relationship of landlord and tenant, therefore the issue of default of payment of rent was not sustainable, and all other issues were in the same manner decided against the plaintiff and in favor of the defendant, and the suit was dismissed. So far as the learned appellate court is concerned, the appellate court, the point of determination were recorded in paragraph 17, which are as follows. The bone of contention is with regard to The point of determination number B relating to the relationship of landlord and tenant. The point number B was decided by paragraph 20. The learned appellate court was of the view that the plaintiff had not claimed eviction on the basis of title, rather the plaintiff had claimed eviction on the basis of being a tenant, being a landlord over the property on the ground of default है ना, पर्सनल नेसेसिटी कैसे लिखा?
दोनों था पर्सनल नेसेसिटी as well as default. Section 14
That's
would
right.
with section
The
11(1)(b).
the learned court also considered that the question of title cannot be gone into under the when the case is for the eviction of suit instituted under Jharkhand Building Lease Rent and Eviction Control Act 2000, and the adjudication is confined only to the relationship of landlord and tenant. The appellate court considered the definition of landlord and referred to the judgment passed by the Honorable Supreme Court in and was of the view that a person who comes upon any immovable property by license of a person in possession shall not be permitted to deny the title. The learned appellate court also considered the provisions of Section 116 of the Evidence Act. The learned appellate court ultimately recorded that it was admitted fact between the parties that Udva Mahadev Mandir is very old. The plaintiff claimed that he had indicted the defendant as tenant through tenancy agreement dated 16/6/99, and that the defendant paid him rent up to June 2005 and neglected and defaulted in payment of rent since thereafter. The plaintiff had relied upon Exhibit 1 series and 2 series, that is the rent receipts and the money order. The learned appellate court further recorded the finding in paragraph 22 of the judgment and referred to the pleadings and observed that the defendant had not specifically denied about his induction to the suit premises by the plaintiff. Rather, he has stated in paragraph 21 of the written statement that the defendant, with respect to the authority, also constructed one of the shop and put shutter and opened the shop dealing in puja samagri in the name of KK General Store. Which was situated in the name of KK General Store. The learned court also recorded that the defendant, in support of his claim that the temple was governed by Hindu Religious Trust Board, did not produce any documents, nor produce any documents to support his claim that he was given the authority to make construction by the trust board. The learned appellate court referred to the Exhibit 1 and 2 series and observed that they were the rent receipts signed by the defendant with respect to the shop. The learned appellate court also compared the signature with respect in the Exhibit 1 series of the defendant with other admitted signatures and observed that exhibits it could not be said that the rent receipts as contained in an Exhibit 1 series were not signed by the defendant. The learned appellate court came to a finding that the defendant had recognized the plaintiff as owner, as landowner of the suit premises. The appellate court further referred to the description of the suit premises The learned appellate court also referred to the judgment passed by Patna High Court in WJC number 3249 of 1994 in bracket R, and observed that it was clearly stated that the removal of temple from the land was not the question, and it could not be said that the temple and the shop situated below the temple have been removed. The learned appellate court ultimately held that there was relationship of landlord and tenant between the parties. During the course of arguments, it transpired that all the rent receipts, rent receipts as contained in Annexure 1 series and the money orders as contained in Annexure 2 series were exhibited without any objection from the side of the defendant. Correct hai na ye? It further appears that
But
though
that is
the
original money receipts. So money receipt is original.
sorry,
Original money receipts. It was given by the plaintiff that were original money receipts.
yes. It further appears that the defendant had claimed that the shop and their premises was being controlled by the Hindu Religious Trust Board Ranchi, but no such documents were produced to establish this fact. So far as the rent receipts produced by the defendants are concerned, they were for the period when the defendants stopped making rent to the plaintiff. Not even a single rent receipt was produced in Exhibit A series, which was for a period prior to 2006. It was a specific case of the defendant that the rent was being paid to the circle officer as the temple was being controlled by Hindu Religious Trust Board Ranchi, but no such document was produced to substantiate such a claim. This court also finds that so far as the kahan hai discussion of rent deed?
Discussion of
Rent deed.
receipts,
नहीं agreement.
agreement. That is submission, my lord.
Submission है ना,
Yes.
submission नहीं लिखा.
That is-
Submission नहीं.
That
This
is
court,
submission, my lord. That is at page 51.
this court also finds that though the agreement was not exhibited in original before the learned court and it was marked X for identification, but certain but the signature and endorsements made on the agreement of both the parties were exhibited as exhibit 3 and 3 by 1
A.
3 and 3 by A without any objection from either of the side. This court is of the considered view that the learned appellate court has duly considered the materials and has in particular referred to the rent receipts produced and exhibited from the side of the plaintiff which were marked without any objection and ultimately held that there was a relationship of landlord and tenant between the parties. In view of the aforesaid facts and circumstances, the question of law is answered in the following manner. The learned lower appellate court has committed no illegality in reversing the judgment. The learned lower appellate court has rightly considered the evidence available on record and has rightly arrived at a finding about the relationship of landlord and tenant between the plaintiff and the defendant. And the finding cannot be said to have been arrived at erroneous conclusions, nor such finding can be said to be illegal or perverse and beyond the weight of the evidence available on record. This court is of the considered view that in an eviction suit filed by landlord against a tenant, there is no scope of going into the title of the tenant of the landlord. What is required to be established is the relationship of handing over rent by the tenant to the landlord. This aspect of the matter having been established from the materials which have been produced by the plaintiff, this court finds that the learned appellate court rightly arrived at the conclusion. The substantial question of law is accordingly answered in favor of the respondent and against the appellant. This appeal is accordingly dismissed. कुछ सवाल तो मुझे के लिए देखते हैं पास ओवर में क्या करते हैं. फिक्स मैटर भी है. किसका फिक्स मैटर है? आपका है. पास ओवर है. और फिक्स मैटर किसका है? फिक्स मैटर किसका? आप लोग का है. अच्छा, जैसे संजीव ठाकुर कर रहे थे, आपका है. सवा 2 बजे. कितना देर लगेगा? क्या मैडम, क्या क्वेश्चन ऑफ लॉ क्या है?
सीरियल नंबर 39 appellant
हाँ.
तो बाप बेटा के बीच में था पार्टीशन. They have settled the dispute out of the court and I have been instructed to withdraw the
कौन सा? FA नंबर?
FA number जो है 23 of 2006. It is arising out of the partitions.
लाइए जरा FA number 20. FA.
Serial number 34, FA number 23 of 2023.
सीरियल नंबर 34 का केस नंबर लिखना
FA number 23.
FA number 23 of 2023. The learned counsel for the appellant on instructions seeks permission to withdraw this first appeal.
Because the matter has been settled.
उतना कुछ नहीं है.
As it's not.
Considering the aforesaid submission, this first appeal is dismissed as withdrawn. Prayer support करते हैं. आज 2:15 बजे जो फिक्स्ड है उसको करेंगे क्योंकि जो पास ओवर हो गया तो दे कैन वेट, दे आर सपोज टू वेट. आपका है 2:15 बजे फिक्स्ड. आपने रिस्पॉन्ड रेडी.
For judgment item 1, the rupiah 1376 of 130.
This repetition is allowed in the aforesaid grounds. The award has been set aside with 50% backwards.
For judgment item 2, second appeal 346 of 2017.
Substantial question of law is answered against the appellant and this appeal is dismissed.
This case for final disclosure item 3, second appeal 503 of 2018.
Can you read it?
This appeal will be heard on the following substantial questions of law: whether both the courts below have committed perversity in declaring the title of the plaintiff by way of adverse possession against the state of Jharkhand, even though the essential ingredients to establish their title by way of adverse possession was neither pleaded nor proved by the plaintiffs.
Did they claim adverse possession? इसका LCR दीजिए. प्लेंट में था आपका एडवर्स पोजीशन.
जो सब्सटेंशियल क्वेश्चन जो फ्रेम हुआ है कहीं ऐसा आया नहीं है.
फाइंडिंग ही नहीं है.
नहीं फाइंडिंग नहीं. पारा 22 ऑफ द जजमेंट लॉर्डशिप में काइंडली सी. Para 22 of the judgment of
We
the.
want to say that this is not arising or this substantial question
Yes,
of law
yes.
is not arising.
Yes.
I just want to know from you, was there any case of adverse possession?
No, there is no case of adverse
There is
possession.
no case of adverse possession.
There is no case of Para 22 lordship में
Okay,
काइंडली
just a moment. You say that there is no case. We'll take it. Don't get back on your words, right? Okay, now show us where is the finding of adverse possession. Yes. Where is the finding of adverse possession?
सबसे पहले तो इशू दिखा दे. फर्स्ट इशू जो इशू फ्रेम था, आउट ऑफ द नंबर ऑफ इशू फ्रेम्स,
Page number?
पेज नंबर 76 आई फाइंड, इंटरनल पेज 9 है.
76. बताइए.
इसके पैराग्राफ 14 लास्ट.
हाँ पढ़िए.
The third issue is क्या वादीगण का वाद परिसीमा विधि व प्रतिकूल कब्जा के नियमों से बाधित है.
बताइए. इशू बना था ये.
कौन सा?
इशू नंबर 3.
नहीं यहाँ तो बना ही है इशू.
आप बोल रहे एडवर्स पोजीशन का केस है नहीं.
हाँ अभी भी बोल रहे हैं.
तो ये गलत इशू बन गया है.
नहीं मैं इसमें कोई फाइंडिंग्स नहीं दिया. पारा 22 एक बार अपीलेट कोर्ट का जजमेंट देख लेते हैं.
नहीं
उससे बहुत क्लियर हो
एक के बाद
जी.
मतलब इशू तो एडवर्स पोजीशन का ट्रायल कोर्ट में बना,
बना
फाइंडिंग
फाइंडिंग्स नहीं आया है, फाइंडिंग्स नहीं आया है।
देखते हैं। इतना हड़बड़ाइए मत, आपकी तरह हम तेज नहीं।
नहीं ऐसा नहीं बोला जाए, हम लोग तो हुजूर से ही सीख रहे हैं।
थोड़ा सा बताइए कहाँ है फाइंडिंग, बताइए कहाँ है?
कहीं भी हमको तो हुजूर नहीं मिला, शायद हम मिस कर रहे हैं।
इशू नंबर 10 दिख रहा है, 1 and 2 दिख रहा है, इशू नंबर 6 दिख रहा है, 4 5, ये 4 5 6 दो बार हो गया।
हम इसी कारण 22 में इसका जिक्र भी किया गया है कि
चलिए है क्या फाइंडिंग? नहीं है ना, तो ट्रायल कोर्ट से तो हो गया क्लीन चिट, कुछ नहीं है, फाइंडिंग नहीं है इनका एडवर्स पोजीशन का, इनका क्लेम भी नहीं है एडवर्स पोजीशन,
क्लेम तो
जो भी है। ही इज नॉट सेइंग, ही इज नॉट इंसिस्टिंग ऑन एडवर्स पोजीशन। यू फॉरगेट
इनका प्लेट का रिलीफ देखते हैं, रिलीफ प्लेट का रिलीफ।
वो बोल ही नहीं रहे हैं उनका एडवर्स पोजीशन का क्लेम, आप जबरदस्ती
अच्छा,
रिलीफ पढ़ा।
इनका रिलीफ है, इनका रिलीफ नंबर बी जो है, that a decree may also be passed in favor of the plaintiff declaring the title of the plaintiff over the suit lands of Schedule A below and is held as a rayat is also perfected by adverse possession.
अच्छा चलिए, इनका एडवर्स पोजीशन का केस नहीं, ठीक है, तो रिलीफ ऑफ एडवर्स पोजीशन आप गिव अप कर रहे हैं ना अपना?
नहीं भी गिव अप नहीं, इनका जवाब देते हैं, फिर हम जवाब देंगे।
सेकंड
अपना केस तो
सेकंड क्वेश्चन
नहीं, आप बोले कि क्वेश्चन ऑफ लॉ ही गलत है, तो हमको तो सुनना पड़ेगा ना, क्वेश्चन ऑफ लॉ ही गलत है तो गलत
पहले उसका हम जवाब देते हैं, उसके बाद हम एक पॉइंट का इनका
नहीं,
जवाब
पहले तो क्वेश्चन ऑफ लॉ की बात तो नहीं सुनेंगे ना।
क्वेश्चन ऑफ लॉ के बाद तो पॉइंट नंबर 2 भी देख लिया जाए, उनका जो फॉर्मूलेट हुआ वो भी मेंटेन
पहले पॉइंट नंबर 1 पे देखिए,
पॉइंट नंबर 1 पर,
ठीक है?
जी।
चलिए, एडवर्स पोजीशन का कोई फाइंडिंग नहीं है, ट्रायल कोर्ट का, एपीलेट कोर्ट का दिखाइए।
1222 देख लीजिए, मुझे बहुत क्लियर हो जाएगा।
अभी आप बोले पहले उनको सुनने ना,
अच्छा, ठीक।
अभी हम उन्हीं को सुन रहे हैं, हो सकता है आपको बिना सुने ही उनका केस डिसमिस कर
एकदम ये तो ऑलरेडी डिसमिस हो गया, इनका केस ही नहीं बनता है।
चलिए बताइए, इसीलिए आप बैठिए,
हम बैठ जाते हैं।
अगर आप बोलेंगे ना तो उनके फेवर में ही कुछ बोल दीजिएगा, इसलिए
नहीं
बैठिए।
फेवर तो बोलिए।
इनका पैरा 22 ही पढ़ रहे हैं, स्टेट की तरफ से हम केस बहस कर रहे हैं, so please don't expect कि आउट ऑफ रिकॉर्ड में कुछ भी बोले।
आपको लगता है आउट ऑफ रिकॉर्ड बोल के आप यहाँ से सक जाइए?
नहीं जा पाएंगे,
नहीं जा पाइए,
नहीं जा पाएंगे।
बस
मतलब इनके लिए बोल रहे हैं।
हमको पर्सनली मत
पैरा 22 बोलिए, हाँ पढ़िए।
पर्सनली
इशू नंबर 2 formulated.
So far as the other issues are concerned, the learned court below formulated issue number 3 as to whether suit is barred by law of limitation on adverse possession, but the learned court below has not discussed or given any finding on the issue. Confirm भी हो गया ये चीज।
हो गया, आगे पढ़िए,
इसीलिए हम 22 को दिखाना चाह रहे हैं।
आगे पढ़िए।
But the learned court below has not discussed or given any finding on this issue. He has discussed issue number 6 twice, which appears in paragraph 30 and 31, which we also saw of the judgment. it appears that there is some typographical error in para 30 of the judgment and issue number 6 was mentioned wrongly in place of issue number 3. This is what it says. Though the suit is not barred by law of limitation or adverse possession, the defendants have not led any evidence, either oral or documentary, on this issue. So this issue is also decided against the defendants. So far as
ये एडवर्स पोजीशन कौन क्लेम कर रहा है? आपका स्टेट का सूट था, सूट किसका था?
suit इनका था.
सूट इनका था. तो डिफेंडेंट्स हैव नॉट लेड ऑन दिस इशू.
I have to prove. Why not?
प्लेंटिफ
plaintiff-
का प्रेयर था एडवर्स पोजीशन.
Yes.
आपको क्या ही प्रूव करना है?
वही तो बोल रहे हैं कि the appellate court is coming to a conclusion that I have not led any.
You are not claiming adverse
I am
possession.
not claiming adverse possession. It was not my suit.
So this issue is also decided against the defendant. इसका क्या मतलब है?
इसका कोई मतलब नहीं है और अगर मतलब है तो दिस इज द रॉन्ग
आगे
कंक्लूजन.
आगे पढ़िए.
So far as issue number 4, 5, 6 are concerned, एक बार फिर हम उसको पढ़ देते हैं उस लाइन को, क्योंकि though the suit is not barred by law of though the suit is not barred by law of limitation or adverse possession, the defendants have not led any evidence.
Never the case of the defendant.
It was not my, but I was not the plaintiff. The defendants have not led any evidence, either oral or documentary, on this issue. Yeah. So far as the issue number 4, 5, 6 are concerned, the learned court below has rightly held that the defendants have to prove all these three issues. But there is no any documentary evidence or oral evidence on these points on behalf of the defendants. The defendants have not filed any documentary or oral evidence to disbelieve the valuation of plaintiff as given in the suit. The said three issues have rightly been decided by the learned court below.
ये कौन सा है? 4, 5 and 6 कौन सा इशू था?
ये तो valuation का
For evidence the suit is barred, waiver, estoppel.
important है ये 4, 5 and 6.
क्या वादीगण का वाद?
ये 5 हम पढ़ रहे हैं.
हाँ.
क्या वादीगण का वाद आवश्यक पक्षकारों के संयोजन से दूषित है? नॉन जॉइंटर. 6. क्या वादीगण ने इस वाद का सही मूल्यांकन किया है तथा पर्याप्त न्याय शुल्क दाखिल किया है?
एंड 4 क्या है?
क्या वादीगण का वाद विविध
Whether the suit is barred, waiver, estoppel, and it is given by principle of specific belief.
अच्छा. This is waiver.
estoppel and
Estoppel.
पेज 15 में appellate court का judgment.
Against specific. आपको रिकवरी ऑफ पोजीशन की तो नहीं मांगे थे?
Recovery position का.
कॉज ऑफ एक्शन क्या था?
I'm in possession of the land.
तो फिर आपका कॉज ऑफ एक्शन क्या था?
Cause of action है कि 145
हाँ, वो
145 46 का प्रोसीडिंग हुआ, उसके बाद हम यहाँ पर आए सूट फाइल करने के लिए.
145 वाज अगेंस्ट.
नहीं, वो 145 को तो हमारा कोई डॉक्यूमेंट्री एविडेंस नहीं लगाए हैं, पर वो हुआ उसके बाद हम लोग फाइल किए हैं.
हाँ, आगे बढ़ते हैं. तो इशू नंबर 4, 5 and 6
cause of action my lords,
इससे क्या ही मतलब है? इससे कोई मतलब नहीं. अब क्या बचा इशू नंबर 1 and 2?
क्या वादीगण का वाद वर्तमान स्वरूप में पोषणीय है? मेंटेनेबल. वादीगण का यह वाद लाने का कोई हेतु प्राप्त
कॉज ऑफ
cause
एक्शन
of action
1 and 2 एपिलेट कोर्ट का डिस्कशन. सो फार एज इशू नंबर 1 and 2 are concerned. सेम इशू लिया है ना दोनों?
एक पॉइंट्स को डिटर्मिनेशन हुआ.
हाँ तो कौन सा पॉइंट?
Para 12.
पेज नंबर पेज नंबर
Page number running internal page 25.
Point
One.
plaintiff acquired right at claim interest over the possession of the suit done in his private the land schedule of the state. Lot number 1142 is the public land of Jharkhand.
That's right. इनका डिस्कशन इसी में है क्या?
Para 13 में है Lordship.
The point number 1 and 2.
So far as issue number 1 and 2.
No, no. This
वो
is
अलग
the
है.
different points Lordship.
These are different.
कहाँ पे डिस्कशन?
Para 13 में page internal page 26.
26.
Point number 3. Point number 1 and 2.
Are taken up which needs to be discussed and adjudicated together. Admittedly, the suit plot along with other land is recorded in the name of Kuwar Rameshwar Narayan Singh as Khewat number 3. The Khatiyan of Khata number 1 of village Nagwan comprising within the suit land has been marked as Exhibit 10. The lands of plot number 1144 and 1146 are recorded as Jungle in column number 8 and recorded as Jhari Bushes in column number 11 of the Khatiyan marked as Exhibit 10. The remark column in Exhibit 10 indicates that the Rayyats were given liberty to reclaim the land of Khata number 1 which were fit for cultivation without permission of the landlord. The entry in Khatiyan is admitted fact of both the parties. Khatiyan is not disputed. The defendants and the witnesses examined on behalf of the defendants also admit the entry of remarks column regarding liberty given to the Rayyats for cultivation or to reclaim the land without permission of landlord. The admission is the best evidence which needs not to be proved. The defendants only plead that jungle as recorded with suit plot was not fit for cultivation. The Khatiyan indicates the type of forest as Jhari bushes, which reveals that there was no any dense forest or reserved trees as classified for forest protected forest. The Khatiyan Exhibit 3 clearly goes to show possession of some persons over the tree standing on plot number 1072, 1088, 1125. The entry in the remarks column also indicates that there was certainly some land for cultivation purpose, so that the Rayyats were given liberty to cultivate the lands without permission of the landlord. The nature of the land is Gair Majurwa Khas. The law has been settled in para 7 of the case of Maya Devi, the state of Bihar, reported in this, that it cannot be said that the lands were recorded as Gair Majurwa Aam, Gair Majurwa Khas, or Kaisare Hind. The settlement in respect thereof and the Jamabandi in respect thereof becomes suspect or becomes illegal. There cannot be any such presumption or assumption. Both assumptions and presumptions are clearly misplaced and relied upon the case of the Chandeshwari Prasad Narayan Dev versus State of Bihar and also in Lakshman Sahay है लेकिन सहानी होना चाहिए. The said observation of Honorable Court has been placed reliance in the case of Yadunandan Singh. Therefore, the defendants cannot say or challenge the settlement on the ground of nature of land being Gair Majurwa Khas as recorded in Khatiyan, which was not fit for settlement. There is no presumption that such type of land may not be settled as per law laid down by the court. The plaintiffs have taken plea also that the land was reclaimed by Vindhyavasini Devi and after satisfaction the landlord administered by manager of what? This is important, this fact I will argue. The plaintiffs have taken plea that the land was reclaimed by Vindhyavasini Devi, and after satisfaction, the landlord administered by manager of wards and encumbered estate get the land measured and settled through Hukumnama to Vindhyavasini Devi. The learned counsel on behalf of the defendants placed argument that the manager of encumbered estate was not entitled to settle the lands, who submitted also that the landlord of Ramgarh estate, namely Kamakhya Narayan Singh, came in ruling power on 7th August 1937, and therefore the manager was not competent to grant any hukumnama or transfer the land without consent of ex-landlord in the year 1942. I will explain this. He claims that he claims title by a sale deed of 1986 executed by the vendor who was granted hukumnama by the manager
I got it.
in 1942.
Your case was that he was nobody.
No, my case was, my argument there was that in 1937, Kamakhya Narayan Singh gained majority, and from 1990 to 1937, that was a period where the manager of the encumbered estate could have executed an hukumnama. But since it is a hukumnama of 1942, which could not have been
Once he
And-
gains
it is
majority.
majority in 1937.
Okay.
So it was a forged and fabricated document, hukumnama. And there comes the second question of law which has been framed.
Kindly proceed further. First of all,
Okay. First of all, I would like to explain the courts of ward of estate and wards and encumbered estate. The courts of ward was a legal body created by the East India Company on a model similar to the courts of ward and liveries that had existed in England from 1540 to 1660. Its purpose was to protect heirs and their estate when the heir was deemed to be a minor and therefore incapable of acting independently. Estate could be managed on behalf of the heirs. The encumbered has been defined as a burden with legal or financial obligation. The encumbered estate, Bhargrast Sampada evam Ringrast, is an estate encumbered with debts. The encumbered estate represents some rights or claim of another to a portion of the property or use of property, a property owned by one party on which a second party reserves the right to make a valid claim. Some reported cases are referred here with a view only to show the rights vested in the manager of encumbered estate. In the case of Hukum Chand versus Ran Bahadur Singh, reported in Indian Appeal, this and this page, the position and legal status and right of manager appointed by the virtue of Chotanagpur Encumbered Estate Act has been defined. According to the observation of the Honorable Court, when the holder of immovable property is a minor or of unsound mind, or when his property has been attached in execution of a decree of a civil court, then upon application, the commissioner may, with the previous consent of Lieutenant General, appoint an officer and vest in him the management of the whole or any portion of property. As per section 13 to 18 of the Act, the wide power of manager are set forth. Up to this point, it is clear that the owner is disabled not only from acts of management but from mortgaging, charging, leasing, or alienating the property. Whereas, on the other hand, the manager is vested and alone vested with such power. As per the decision of manager was in the list of public servants. In a case of state of Bihar versus Bimla Kumari reported in 1969, 17 DLGR 815, Chandra Mauleshwar Narayan Singh became the holder of the imperitable state in the year 1929. The estate was applied to be taken for the purpose of management under section 2 of the Chotanagpur Encumbered Estates Act. The estate was accordingly taken over on 13th May 1930. It was released on 22nd November 1946 in favor of Mauleshwar Narayan Singh, the then holder of the estate. In less than a year after the release of the estate, Chandrasekhar Mauleshwar Narayan Singh executed on the 28th September 1947 4 post grants in favor of his wife. The preamble of a Chota Nagpur Encumbered Estate Act has been defined in para 9 of Vimla Devi case. The preamble of the act says that it is being enacted because it is expedient to provide for the relief of the holders of land in Chota Nagpur who may be in debt and whose immovable property may be subject to mortgages, charges, and liens. The effect of the order of vesting of management of the property in an officer appointed by the Commissioner under Section 2 of the Act is mentioned in Section 3. It is manifest, therefore, that so long the estate remains under the management of the manager, the holder of the estate cannot alienate it or any part of it even by maintenance grant. In another case of Hari Krishna Prasad Keshari versus State of Bihar and others, since reported in 1995, BLJR 604, the recorded tenant by virtue of the registered deed of surrender dated 9/11/36 surrendered the said lands to the manager, Bhargav encumbered state by virtue of a registered Hukumnama 21/7/1938. The manager aforesaid settled the land with one Sheikh Muhyiddin and put him in possession of land and also granted rent receipts. The aforesaid Sheikh Muhyiddin by virtue of registered seal deed dated 16/1/63 sold the said lands to these petitioners and put them in possession of the same. Thereafter, the name of the petitioner will be mutated in the government record and the petitioners are paying rent to the state. The sons of a recorded tenant filed a case under Section 71A of the CMT Act for restoration of plot number 1000 besides other land, which was allowed in appeal. The petitioners preferred revision, which was dismissed, and then the petitioners.
The petitioners are who? The appellants, na?
Hari Krishna
It is
Prasad
referring
Keshari
to that judgment.
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 All right.
The petitioners preferred revision. All these judgments are just showing the powers of the manager under the Encumbered Estate Act. The petitioners preferred revision.
So where are these judgments? We will not take whatever is written only. And where is the act by which they are governed?
I don't have also the act notes. भी बहुत किताब
आपके
दुकान
पास भी नहीं है.
किताब दुकान वालों को बोले पूरे खोल रहे हैं.
My lord, the second question of law एक बार हम पढ़ लेते हैं, उसके बाद आगे पढ़े तो.
हाँ ठीक.
First was adverse possession. Second was whether the courts below have committed perversity by failing to consider that in the year 1942, no ward of encumbered estate was in existence as the same ended in the year 1937 and Padma state was under the direct control of Raja Bahadur Kamakhya Narayan Singh. Therefore, the case of the plaintiff of settlement by Sada Hukumnama dated 7/11/42 was a concocted one. So, this Hukumnama which he claims that his vendor was granted was by the manager estate in 1942, whereas in 1937, Raja Bahadur Kamakhya Narayan Singh, after gaining majority, he was only capable of giving any kind of none. So it was a forged and fabricated document which was exhibited by.
You see, forged and fabricated is different from an illegal document. He had no jurisdiction to give, that is your case. What do you mean by forged and fabricated? Forged and fabricated means the document itself is forged.
Yes.
That is forgery. Suppose your case is that he was not competent.
Not competent. No. Okay.
Forged and
Okay.
fabricated is a different thing
If we
altogether.
put in these two,
Not competent.
it may be forged and
We do not know. There is no
Maybe.
finding that it was
but
forged
that
and fabricated.
Hukumnama was
He was incompetent. अब हाँ पर हम किसी को हुक्मनामा दे देंगे तो क्या ही हो जाएगा? It will not become forged and fabricated. It will be an illegal document.
It will fall in a category where we can say that we can transfer only
Whatever we have.
whatever we have.
That's right. So he had no jurisdiction to execute that.
Execute. And moreover, my lord, now if this suit with a prayer on the basis of adverse possession was filed, then he is a subsequent purchaser. Adverse possession, if at all, was of his vendor, who was not a party to the suit. So on the
He is
ground,
successor in interest.
No relief for as claim.
But you can have both ways, title B or adverse B. Simultaneously you claim both.
Yes, there is a decision of the Honorable Supreme Court, Lord से reported is 2019 8 SSC 729. हम लोग दोनों कर सकते हैं. आज कोई जजमेंट हम लाए नहीं हैं.
Is that correct? Whatever he is saying?
रविंदर कौर केस लॉर्ड से रिपोर्ट 2019 8 SSC page 729.
2019.
8 SSC page 729. I do not remember the paragraph, Lord. I will show
You
to
continue reading, please. In view of the aforesaid decision, you read from here. In view of the aforesaid decisions of the Honorable Court, the manager of ward of encumbered estate was competent to mortgage, lease or settle the land on behalf of the landlord.
page
Page 30.
30. In view of the aforesaid decision of the Honorable Court,
Which
30 internal. In view of the aforesaid decision of Honorable Court, the manager of wards and encumbered state was competent to mortgage, lease or settle the land on behalf of the landlord when the estate was under the encumbrance and the landlord was not competent to settle the land to anyone. The case law reported in AIR 1973, Supreme Court 782, Balai Chandra Mandal versus Indu Rekha Devi and others, as referred on behalf of the appellant, defendant is not at all applicable in this case, since it is not a case administered by manager of wards and encumbered estate. The plaintiff has taken plea that Vindhyavasini Devi reclaimed the land of plot number 1144 and 1146 and the landlord administered by the manager wards and encumbered estate get the land measured by an ameen and fixed rent and granted hukumnama. The defendants have denied the said fact as pleaded by the plaintiff and have taken plea that the settlement papers must be forged and fabricated papers, which are manufactured recently to lay false claim. It is settled principle of law that pleading is not itself a proof. The plaintiffs have filed an ameen report, hukumnama paper and rent receipt of landlord in proof of his contention. There is least possibility for the plaintiff to produce any direct oral evidence on the point of reclamation or measurement of land due to event of long past. The defendants, if denying the alleged fact of blame, he must not do so evasively but answer the point of substance as per the provisions given under Order 8 Rule 4 CPC. There is provision also under Order 6 Rule 4 of CPC that in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful deceit or undue influence, and in all other cases in which particulars may be necessary beyond, such as are exemplified in the forms aforesaid, particulars with dates and items if necessary shall be stated in the pleadings. It has been held in the case of Fayyaz Ahmad and others versus Amir Ahmad reported in 2010 that if the defendant denies the fact in the plaint, he must be specific, and if it does not deny specifically or by necessary implication, it shall be taken to be admitted. So, I denied this hukumnama on the basis of being an hukumnama executed by an incompetent authority. It is there in my written statement. The defendants have simply denied the settlement or measurement of land and have taken the plea that same must be forged and fabricated. The defendant have not given any oral and documentary evidence except the notification of Forest Department to falsify the document Amir report. This last 4 lines are related to this case. The defendants have not given any oral or documentary evidence except the notification of Forest Department to falsify the document Ameen report marked as Exhibit 3 Hukumnama marked as Exhibit 13 and rent receipts marked as Exhibit 12 to 12C. So it was a forest land. A notification under Section 2930 was marked as an exhibit.
Was there any objection raised in connection with this notification at any point of time? By any of these people? No, that has not come up.
यहाँ नहीं है. Further, this
This
is
notification is of the year?
1953.
53.
353, 55 के हम दिखा देते हैं.
ठीक. Further, can you read?
Further, this is not a case of the defendant that the estate was given and administered by manager of ward and encumbered estate. The defendant's appellants had taken a ground in memo of appeal that Kamakhya Narayan Singh had become a major in 1937 and the estate came in direct control in his hand and the encumbered estate came to an end in the year 1937. The Hukumnama granted by manager encumbered estate in the year 1942 itself becomes doubtful. This assertion of appellant defendant is an admission to the extent that the state was under the administration of manager of wards and encumbered estate till 1937. There is only plea of appellant defendant manager that manager was not entitled to measure or grant settlement and the landlord had come in power in 1937.
Has the plaintiff produced any rent receipt prior to the purchase of the property in 1986? Yes. They purchased the property in 1986.
They purchased the
Is there any rent receipt prior to this date? As exhibit?
as exhibit it was. I'll show. ये तो है. पेज 77 में एग्जिबिट्स का डिटेल है. 77 ब्रीफ का. मेरा इंटरनल पेज 10.
देखिए तो क्या क्या एग्जिबिट्स
हाँ,
हैं?
एग्जिबिट क्या क्या था दोनों तरफ से. पैराग्राफ 15. उभय पक्षों ने अपने अपने दावे के समर्थन में कुछ मौखिक एवं दस्तावेजी साक्ष्यों को न्यायालय में प्रस्तुत किया है. वादीगण ने मौखिक साक्ष्य के रूप में 14 साक्ष्यों को परीक्षित कराया. जो वादी संख्या ये 14 नाम है. ठीक है. उसके बाद दस्तावेजी साक्ष्यों के रूप में वादीगण ने निबंधन केवाला संख्या 994 दिनांक 21/2/1986 को प्रदर्श एक सरकारी रसीद संख्या 1182/804 and many other rent receipts को प्रदर्श 2 से 2G. So these are the receipts.
पेज 31 में अपीलेट कोर्ट में बहुत अच्छा डिस्कस किया हुआ डॉक्यूमेंट्स के बारे में लोग. पेज 31 ऑफ द लर्निंग फर्स्ट अपीलेट कोर्ट लोग. इंटरनल पेज 16 रनिंग पेज 31.
टू जी ये कब का रेंट रिसीट है? एग्जिबिट 1 देखिए रजिस्टर्ड डीड है 21/2/86. एग्जिबिट 2G इज गवर्नमेंट रेंट रिसीट्स. कहाँ ही लिखा हुआ है इसमें? नॉट मेंशन्ड ओवर हियर. एग्जिबिट ए और एग्जिबिट बी का भी डेट नहीं लिखा.
एग्जिबिट 12 to 12 जमींदारी रेंट रिसीट्स.
2 and
12 to 12 by C जमींदारी रेंट रिसीट्स.
यह गवर्नमेंट
गवर्नमेंट का तो एग्जिबिट 2 to 2 by G. तो मोहिनी देगी ने जो हम परचेजर है उनके नाम से. जो परचेजर है उसके नाम से लॉट्स.
सारा एग्जिबिट 2
जी
2 सीरीज जितना.
बिल्कुल
पहले
पहले का नहीं. तो मोहिनी दे के नाम से जो हम परचेजर हैं
सारा का सारा बात कर
बात कर
बात तो बोली
एक भी वो रेंट रिसीट पहले का नहीं है।
नहीं।
अब इमीडिएटली प्रायर टू परचेज कौन सा रेंट रिसीट?
एग्जीबिट 2/G में ही उसमें पढ़ नहीं पा रहे
नहीं पढ़ पाइएगा। काम का चीज पढ़ना नहीं सीखिएगा तो कैसे ही क्या होगा? बताइए।
86 का बात कर का है, 99 का है, 98 का है, 96
I have to say that if he is sailing on both the boats by claiming on the basis of adverse possession as well as on the basis of the hukumnama. So when if hukumnama he relies upon, then a issue should have been framed, my lords, with regard to the validity of the hukumnama.
एक बार एग्जिबिट 2G देखा जाए तो एक 56 का रेंट रिसीट्स मिला है एग्जिबिट 2/G 28 कितना 28 विद्यासिनी देवी के नाम से पारा 8 ऑफ द प्लेंट में हम दिए भी हैं, इसके बारे में लिखा हुआ है 27/2/55
इसमें तो ब्लैंक कुछ समझ नहीं आ रहा।
ये हम तो पढ़ पा रहे हैं और पारा 8 ऑफ द प्लेंट में स्पेसिफिक लिखा हुआ भी हमारा है पारा 8 ऑफ द प्लेंट में लॉट्स
क्या लिखे हैं?
पढ़ that accordingly rent receipt was issued for the first time on 27/2/1955 at receipt number 288593 on realization of rent for the year 1953-54, 1954-55. Thus, Jamindari was legally opened and rent receipt continued to be issued in the name of Vindhyasini Devi regularly by Karamchari on realization of land and her permanent Rayati Raj were recognized and accepted as per the government instruction.
उसके बाद इस रेंट रिसीट के बाद
उसके बाद हमारे पास नहीं, उसका मोहिनी अगर रेंट रिसीट कटा भी होगा तो हमारे पास नहीं है। इनका मेन केस है सेक्शन 29 एंड 30 ऑफ द फॉरेस्ट एक्ट, बट 31 एक बार देख लिया जाए, वो कभी पब्लिश ही नहीं हुआ है। 31 का कंप्लाइंस ही नहीं हुआ इनका।
नहीं तो फॉरेस्ट
31
ये
का
इशू तो बहुत केसेस में है।
जी
ये इशू तो बहुत सारे
बहुत से
केसेस
केसेस में है, बहुत सारे 31 का कंप्लाइंस ही नहीं हुआ है।
कहाँ पे आपके ऐसा फाइंडिंग है कि 31 का कंप्लाइंस नहीं है?
हम तो दिखाएंगे, हम जब बहस करेंगे
Finding है।
हाँ हम दिखाएंगे।
वही कर रहे हैं।
नहीं नहीं आप कीजिए, हम नहीं कीजिए क्योंकि माय लॉर्ड के प्रोग्राम था इसीलिए ऊपर नहीं
कोई दिक्कत नहीं है। Unless we speak simultaneously.
और दूसरी बात है कि सेक्शन 29 और 30 जो नोटिफिकेशन होता है 30 इयर्स बाद अपने आप खत्म हो जाएगा।
This is publication of translation of such notification in neighborhood.
हाँ
The collector shall cause a translated
31
31. Translated copy का publication नहीं।
हाँ पब्लिकेशन नहीं होगा।
कहाँ है finding?
30 हम दिखा देंगे जो इनका खत्म
अरे
होने
दिखाइए
के
ना, खत्म नहीं, पहले दिखाइए, बहुत इम्पोर्टेंट है। दिखाइए कहाँ?
There were two exhibits filed on behalf of the defendants. I am reading from page 78. प्रतिवादी गण ने दस्तावेजी साक्ष्य के रूप में अधिसूचना धारा 29 एवं 30 की प्रमाणित प्रतिलिपि को प्रदर्श ए और A/1 एवं अधिसूचना धारा 30 की प्रमाणित प्रतिलिपि को प्रदर्श बी में दाखिल किया है। यही दो चीज हुआ है। And that notification includes both these plots. Although he is confining his prayer only with respect to one of the plot 1144 and not 1146.
हाँ पेज 35 में नोट्स की क्वेरी
उनका सबमिशन है।
When the
हुआ है।
council submitted that all the forest land
Yes.
and had notified had notification dated so and so under section 14 of Bihar Private Forest Act 1946, the suit land vested under the provision of Bihar Land Reform Act. Their land was notified as protected forest under section 29 of the Indian Forest Act and comes with the purview of the public. Submitted the कर्मचारी has no power to issue rent receipt. ये इनका सबमिशन है।
वो तो है कि when a notification has been issued, thereafter a कर्मचारी could not have issued such a rent receipts, and therefore a cancellation of जमाबंदी case was या doubtful जमाबंदी case was instituted in 1890 against विद्यावासिनी देवी।
ये बोल रहे हैं कि there is a publication of notification under section 31 of the Indian Forest Act. उसका कोई डॉक्यूमेंट्स नहीं लगा, एग्जिबिट नहीं हुआ, वो डॉक्यूमेंट ही एग्जिबिट नहीं हुआ।
फाइंडिंग्स फिर पैरा 11 से कहानी शुरू हो गया फिर से। पैरा 11 पेज नंबर 24
Page number
24 और द एप्लेट हो जाए इंटरनल पेज।
The plaintiff respondent had brought the suit for a decree waiver declaring the suit land described in Schedule A is not a public land and for declaration of the title of the plaintiff over the suit land as the rayet and for a decree of a permanent injunction against the defendants stringently not interfering with the possession of the plaintiffs in any manner. The suit land is situated in this village, Khata number 1, plot number 1144.80 acres. Recently, the plaintiff filed and proved a certified copy of order dated 9/4/18 passed in WPC 4965 of 2016 by the Honorable High Court of Jharkhand, wherein the petitioner challenged the notice dated 21/6/16 issued by the collector cum DFO South Forest Division Chatra under section 3 of the BPLE Act. The Honorable High Court has been pleased to pass the order. In due notice dated this, issued by the respondent number 2 cannot be sustained in law and the same was quashed. The Honorable Court has been further pleased to hold that the issue regarding the petitioner being encroacher over the land in question shall be subject to the outcome of TA number 8 of 2012 preferred by the respondent state in this court. This is TA number 8 of 2012. The plaintiffs filed the suit with the contention that the suit land along with other lands were reclaimed by one Vindhyavasini Devi, who was in the possession and subsequently acquired the land through settlement given by the then manager of wards and encumbered estate followed by Jamindari rent receipts. Vindhyavasini Devi get her name mutated in the register of state and subsequently she transferred the land to Mohini Devi, here the respondent, through a registered sale deed on 21/4/1986. Plaintiffs constructed house and well over the land and surrounded with a boundary wall. On the other hand, defendants appellants have taken the plea that the nature of the land is Gairmajurua Khas, recorded in the jungle in the Khatian of Khata number 1 of village Lagwan. The manager of ward and encumbered estate was not entitled to transfer the land through Hukumnama, which is an unregistered document and inadmissible in evidence. The Hukumnama and rent receipts of ex-landlord is not genuine. They have taken a plea also that the suit land is notified protected forest land and Vindhyavasini Devi never reclaimed the land and came in possession. The learned court below decreed the suit on contest without cause. The learned court below discussed and advocated firstly issue number 8, which is the core issue of the suit regarding right, title and interest and possession of the plaintiff. This issue number 8 was kabja, possession.
There is no flow in that. Discrete.
ठीक.
अब हो गया 4:40 मिनट. ये जितने भी जजमेंट्स इसमें रेफर्ड हैं सारे चाहिए क्योंकि इट्स अ वेरी इंपॉर्टेंट इशू. इसको हम इतना लाइटली नहीं डिसाइड कर सकते. It has a bearing in large stretch of land, isn't it? Correct?
The judgments have been, some of the judgments are with regard to the powers of the manager.
So your argument would be with regard to powers of manager, or your argument would be with regard to the notification issued by the forest. So when you are relying upon both the points, so whatever judgments have been relied upon by the appellate court, those are required to be seen. पेपर टू बनाइए और वो जो स्टेट का जो मिल गया है सेक्शन
उसको भी हम लोग देख लेते हैं.
उन्होंने दिया, आपके पास था ना सीएमटी एक्ट में है.
नहीं, हमारे पास जो है उसमें नहीं है. दूसरे पब्लिकेशन को
पावर ऑफ मैनेजर.
यहाँ जो पावर ऑफ मैनेजर का बात ही नहीं है. ये जो बोल रहे हैं पावर ऑफ मैनेजर का, इनका डब्ल्यूएस में प्लीडिंग ही नहीं है. कोर्ट का फाइंडिंग्स देख लिया जाए. ये फर्स्ट अपील में लिखे हैं कि उनको पावर नहीं है. हाँ, फाइंडिंग्स है. लॉर्डशिप मे कैन यू सी द
ट्रायल कोर्ट का जजमेंट से लिखा गया है.
लेट मी कंप्लीट. लॉर्डशिप मे कैन यू सी पेज 32, इंटरनल पेज ऑफ 32 ऑफ द लर्नेड फर्स्ट अपीलेट कोर्ट लॉर्डशिप. इनका प्लीडिंग ही नहीं है. जो सेकंड सब्सटेंशियल क्वेश्चन ऑफ लॉ इनका मेंटेनेबल ही नहीं है. ये फर्स्ट अपील में लिखे हैं कि मैनेजर इज नॉट ए कॉम्पिटेंट.
page 85, which is a part
Lordship,
of
may
the-
kindly see page 32, Lordship. Only I will take 1 minute, and subsequently, Lordship, I will argue this case. May kindly see page 32, internal page, Lordship. Internal page 32. एकदम नीचे से 7-8 लाइन, लास्ट लाइन. Further, the further appellants defendants had taken another ground in the memo appeal that Kamakya Narayan Singh had become major in the year 1937, and the state came in direct control in his hand, and the incumbent state came to end in the year 1937. The ground is taken by the appellant in the memo appeal may not be appreciated in right perspective. There is no such pleading in WS of the defendants. WS में लिए ही नहीं है, तो अपील में एक पॉइंट कैसे ले सकते हैं? और उसी पॉइंट का आधार पर सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम हुआ है. ये दिखा दे WS में.
दिखा रहे हैं पेज 18 of the trial court judgment as page 85 में देख लें.
नहीं, WS से दिखाइए ना, रिटेन स्टेटमेंट से दिखाइए.
पेज 85, इंटरनल पेज 18. वादीगण के विद्वान अधिवक्ता का यह भी तर्क है कि रामगढ़ राजा नारायण सिंह 1937 को व्यस्त हो गए थे, इसलिए 1942 में मैनेजर वार्ड इनकम्बेंट डिस्ट्रिक्ट होने का कोई प्रश्न नहीं उठता है.
ये जो आप आर्गुमेंट किए, इज इट बेस्ड ऑन सम प्लीडिंग या ऐसे ही आर्गुमेंट
नहीं
करें?
है, वो भी है, हम देख लेते हैं.
नहीं, प्लीडिंग है नहीं, हम तो बोल रहे हैं कि प्लीडिंग नहीं है.
अब अपना WS भी देख लेते हैं.
हम WS पढ़ के आए हैं, कोई प्लीडिंग नहीं
आर्गुमेंट तो
है.
हुआ है.
आर्गुमेंट होने से नहीं होगा. प्लीडिंग इज वेरी मच इंपॉर्टेंट.
This is a very important fact.
Yes.
The fact cannot be bypassed.
And there
If
is
it cannot be bypassed, then it is required to be
pleaded.
specifically pleaded. Isn't it?
According to the Order 6 Rule 1, Order 6 Rule 2, and there is a direct judgment 2008-17 SSC, page 491, Lordship. अगर नहीं है प्लीडिंग तो सेकंड सब्सटेंशियल क्वेश्चन ऑफ लॉ ऐसे ही खत्म हो गया.
पेज 6 जो है ये तो लिखा हुआ है WS का. On the basis of the same, no parcha dated 14/8/1942 and hukunnama dated 7/11/42 and rent receipts were issued in the name of Vindhyavasini Devi. The aforesaid plots were recorded jungle, so it was not fit for reclamation, and hence the ex-landlord had no right to settle the same. If any settlement papers are being filed, it must be forged and fabricated.
Manager of arts, whether he is a competent or not, there is no pleading.
पैरा 5 का क्या रिप्लाई है आपका WS में?
फाइव का ही रिप्लाई हम पढ़ रहे हैं, आप पढ़ सकते हैं. That the statements made in para 4 and 5 are not correct and hence it is hereby denied. It is submitted that Srimati Vindhyavasini Devi, wife of late Munna Dikshit, was not the settled resident of village Nagwan. Besides this, she was also not the resident of the said village. She has also not, with the help of her husband, reclaimed 1 acre of land out of 22.80 acres in plot number 1140 and 4 acres out of 37 acres in plot number 1146 of Khata number 1 of village Nagwan and not converted it into Tar 3 and before 1942 and enjoyed its usufructs thereof. The story of reclamation is false and fabricated. One, as the land was not fit for reclamation, is against the provision of Khatiyar. It is further submitted that manager Ward, an encumbered estate, had not settled any portion of land of Khata number 1, plot number 1144 and 1146 of village Nagwan, as well as there was no occasion to measure the alleged reclaimed land by the Amin, and on the basis of the same, no any parcha of 14442 and Hukumnama of 71142 and rent receipts were issued in the name of Vindhyavasini Devi. The aforesaid plots were recorded general, so it was not fit for reclamation, and hence the ex-landlord had no right to settle the same.
So your case was that the ex-landlord had no right to settle the same because it was already a jungle. That was your case.
It was the jungle, and that is by having no right.
इसको थोड़ा सा सुने हैं काफ़ी देर, कंटूर्स भी आप सीन, थोड़ा नोट्स बनाइए और जजमेंट्स लेके आइए, जो जो जजमेंट इसमें रेफर। आपका ये केस नहीं है कि वो मेजर और माइनर और ये सब कोई कहानी आपको
आर्गुमेंट में हुआ।
इधर द मैनेजर
आर्गुमेंट से कैसे चलेगा?
ठीक है, आर्गुमेंट
आर्गुमेंट में बताइएगा कि वो आदमी तब मेजर हो गया था, ऐसे तो नहीं चलेगा ना, ये तो नहीं चलेगा ना। आपका अमेंड करना चाहिए था, आपको अपना रिटन स्टेटमेंट अमेंड करना चाहिए, ऐसे नहीं हो सकता। तो जुडिशियल प्रोनाउंसमेंट भी है, वो भी चेक कर लीजिए। वी डू नॉट नो if there is any finding in any judicial pronouncement, but apparently तो आपका ये प्ली है नहीं, आपका ये प्ली है फॉरेस्ट लैंड था, it could not be settled.
and those are exhibits also.
Those are exceptions. But this plea that he ये जो encumbered state का जो सहारा कहानी किया है appellate court, that is absolutely beyond the pleading. Right?
WS में
नहीं, फर्स्ट अपील में फर्स्ट टाइम वो प्लीडिंग लिए हैं,
हम WS
मेमो अपील में लिए फर्स्ट टाइम।
नहीं है ऐसा,
It is not permissible.
Beyond plain and written statement में हम आपको जाने नहीं देंगे। सरकार है तो कुछ भी करेंगे, ऐसा थोड़ी होता है। जजमेंट लेके आइए, आप लोग थोड़ा नोट्स बनाइए और जजमेंट लेके आइए। लिखिए सेकेंड अपील नंबर 503 of 2018. Heard the learned counsel appearing on behalf of the parties. As the court time is over, the arguments have remained inconclusive. The learned counsel for the parties have submitted that they shall also prepare themselves and they shall prepare short notes and on the basis of contours of the case, contours of the points which are involved in this case in relation to the point substantial question of law involved. They also undertake to file copy of the judgments which they seek to rely upon. अगर beyond pleading है तो वो estate का सारा काम ही खत्म कर देंगे, उसका कोई मतलब
नहीं,
नहीं।
कोई प्लीडिंग ही नहीं।
वो आपको प्रूव करना है भाई, बहुत ध्यान से देखना है। अभी 5 मिनट देखें, ऐसे नहीं कर सकते।
ठीक, डेट मुझे कब रखा गया?
हाँ डेट बताइए कब चाहिए आप लोग?
एक सप्ताह के बाद रख दिया जाए, हम लोग नोट्स भी बना लेते हैं, जजमेंट भी ले लेते हैं।
ट्यूसडे
नेक्स्ट वीक
नहीं, वेडनेसडे इन द सप्लीमेंट्री क्लॉज लिस्ट फॉर फर्दर हियरिंग।